This is Bill O'Leary from Legacy Planning Law Group, and welcome to the Estate Settlement Program podcast series. This is a podcast designed to be listened to before Module 2, called the Legal Module, in the 7-module Estate Settlement Program. Now, you're going to be meeting with your legal team shortly, and before you do, we thought we'd give you a little primer here on what a probate is and what a trust administration is, and if you're going to be acting for your loved one, maybe as the personal representative of his or her estate, or maybe the trustee of his or her trust, what you'd be doing as the personal representative or the trustee. So in both circumstances, we want you to know the things that you'll need to know before the meeting. And so this is a short podcast that will give you a little primer that hopefully will arm you with some questions and some ideas, so you'll be better informed when you do talk to us. So the first thing I'm going to go over today is to talk about what a probate is. Now, you may say, look, my loved one, died with a trust, so there should be no reason for a probate, right? Well, generally speaking, that's the case. But let's talk about what a probate is just for a moment. The probate has nothing to do with taxes. You see, probate is a legal process. So let me use the example of, let's say, John Smith. And let's say he was survived by his wife. Her name's Jane. And let's say John owned an asset in his name individually. Maybe it was a checking account, maybe a CD, maybe even some sort of investment account. He didn't own it jointly with his wife, though, with rights of survivorship. And he didn't own it in a trust either. He just owned it in his own name. Well, to get that asset titled in accordance with his will or with his trust, we're going to have to open up a probate. Now, if the total value of all of those individually owned assets is less than $75,000, and if John had no creditors, then there's an abbreviated administration available known as a summary administration, which we'll talk to you about if that's the case for you. But here we're going to talk about what's called a full probate administration, where John may have had assets in his own name higher than $75,000 at the time of his passing. So then what is a full probate? Well, it's a process. And what happens first is John's will is admitted to the court, to the probate court, as his last will and testament. This gives everyone the ability to say, hey, John had this codicil, this later change to the will that maybe you didn't know about, and so this person might try to admit the codicil instead of the original will. Now, generally speaking, that doesn't happen. So the will ends up getting admitted, and the personal representative that's named in the will, let's say in this case it's Jane, his wife Jane, she ends up being appointed as the personal representative. You may be familiar with the term executor. A lot of other states use that term, but in Florida, we use the term personal representative. And John's wife, Jane, here is the personal representative, and she receives something from the court called letters of administration. These letters of administration, once signed by the judge, give Jane the authority to act on behalf of John's estate, and she can go to the bank with these letters of administration and retitle any of John's accounts that are in his name individually, retitle them into the estate name. And we'll help you with that. Our office does that for you. You see, we coordinate that with the banks and the brokerage firms. Typically, we have to get a new taxpayer identification number in order to transfer the assets. Now, after the personal representative is appointed, he or she marshals the assets of the administration, and she uses her letters of administration to act with authority. After that, then creditors are notified. Now you might say, well, hey, my loved one didn't have any creditors when they died. There were no unpaid bills. Well, that might be the case. There might be, however, a last doctor's bill that you don't know about, or maybe a last hospital bill, or perhaps it was a credit card that wasn't fully paid. You know, these sorts of creditors, we have to send a certified mailing to them. Again, the law office does that for you. We give them what's called a legal notice to creditors. We also publish in a newspaper a notice to creditors, and that gives any creditor 90 days in which to file a claim against the estate, and for most circumstances, they are forever barred if they don't respond. Now, the creditors who are secured, well, what's a secured creditor? That would be like a bank who has, let's say, a mortgage on the home. That's a type of secured creditor. Or another example of a secured creditor might be a bank that loaned money for the purchase of a car. Those types of secured creditors are not forever barred because they have what's called a security interest. But unsecured creditors that don't have a security interest, again, these are creditors like doctors and hospitals and credit cards. Those creditors have to file a claim against the estate or they are barred forever. Then inventories are filed. We file an inventory with the court as to the assets of the decedent that were in the decedent's name. Eventually, accountings are filed and beneficiaries are allowed to review the accountings and to approve or contest the accountings. And then, once all that is complete, distributions are made. And of course, taxes are paid, and then finally the estate is closed. So that's the probate process. Now, if the decedent had just a trust and all the assets were in the trust, do we need to worry about a probate process? Well, typically we don't, but there's something that you should know. If you're acting as the trustee of a trust, okay, so let's say it's your father's trust. Let's make Judy John's daughter. So John passed away, and Judy's the daughter, and let's say there was no surviving spouse, and Judy is about to make distribution of the trust to her siblings or to any other of the trust beneficiaries. Now, if we don't open up a probate for the specific purpose of clearing the creditors, something we call an empty probate, we have the ability to actually open up a probate even if there are no assets, solely for the purpose of clearing the creditors and force them to file a claim within that 90-day period. So what if Judy doesn't do that? What would happen? Well, let's say Judy makes a distribution of all of the trust assets shortly after her father John's death. Well, let's say a valid creditor then comes by. Let's say it's a Visa card that has $7,000 on it and a hospital bill that wasn't covered by insurance or those sorts of things. Well, Judy maybe can hope to ask the beneficiaries for a refund of part of the distribution. Well, of course, that's not likely. But if she doesn't get it, she, Judy, if she accepted the role as trustee, is personally liable to that creditor. So Judy must be very, very careful not to make full distribution, and creditors have 2 years in which to make a claim under Florida law against Judy as the trustee of her father's trust after his death. So what's Judy to do? Well, one thing that Judy can do, as we mentioned before, is to open up an empty probate to clear all the creditors, even if one isn't necessary. Because the loved one didn't die with any assets in their own name, because all of them were in the trust. Why? Because Judy can put potential creditors on the clock and shorten the time period that creditors have to bring a claim, shorten it from 2 years down to 3 months. So again, an empty probate can be opened up to clear all the creditors, even if one wasn't necessary, again, because there were not any assets that your loved one owned at their death. Going through this empty probate will bring relief and comfort to Judy, knowing in only 3 months' time there are no creditors out there. Now, another option, of course, is to hold amounts in reserve during the 2-year period. Now we have a surviving spouse, and a good majority of the trust is held for the surviving spouse's benefit, and we're confident that the surviving spouse is going to live at least 2 years. If that's the case, then there may not be a problem, and there may be no reason to open up an empty probate, because in that case, you're reasonably certain that the trustee will have control of the assets for the 2-year period in case the potential rogue creditor shows up. So that's really what we're going to go through here in Module 2. Again, we call it the legal module. So just to wrap up for this particular module, First, we're going to discuss whether a probate administration is even necessary if our loved one had any assets in his or her name individually, and if they did, whether that will require a summary administration, something that's relatively easy to accomplish, or whether we then have to open up a full administration. And I really haven't even talked about something called an ancillary administration, and that's where maybe our loved one owned property in his or her name, usually real estate, but owned it in another state. Let's say we have a house or a building or some other form of real property owned by our loved one in another state. We're going to have to open up an ancillary administration in that other state and find an attorney there. Now, that's not very common, but occasionally it occurs. So we'll have to determine first if a probate administration is even necessary. If a probate administration is not necessary legally, then you'll have to decide as trustee if you want to clear the creditors or if you're comfortable living with the uncertainty of waiting out the 2-year statute of limitations. That's something you're going to be talking about with your legal team. So we hope that this podcast provided some comfort and clarity, and we look forward to speaking with you very soon.